Grandparents' rights in Texas. Grandparents often provide emotional stability, cultural heritage, and crucial guidance in a child's life. In Texas, where family dynamics can shift due to separation or loss, the legal system recognizes the importance of maintaining grandparent-grandchild relationships. Understanding these rights can help grandparents stay involved when it matters most. Texas law acknowledges that while parents typically have primary rights to decide their child's upbringing, grandparents may intervene legally under specific conditions. The Texas Family Code Section 153.432 allows grandparents to petition for visitation or custody if it's in the child's best interest. Courts consider whether the child could suffer harm if this relationship is disrupted and assess the grandparent's ability to provide a nurturing environment. However, these rights are not automatic. Courts exercise discretion and weigh various factors, prioritizing the child's overall well-being. The U.S. Supreme Court case Troxell v. Granville significantly shaped how Texas courts approach these cases. Because of this ruling, a parent's decision to deny visitation is presumed valid, and grandparents must overcome a high legal standard. To challenge a parent's decision, a grandparent must prove that denial of access would significantly impair the child's physical health or emotional well-being. Evidence such as professional assessments or professional testimony is often required to meet this standard. A knowledgeable attorney can help grandparents gather the right documentation and navigate these challenges. Grandparents in Texas must follow the SAPCR process, suit affecting the parent-child relationship, to request visitation or custody. This legal route requires a formal petition detailing the nature of the relationship and the reason for intervention. If an existing court order is in place, it can be modified by presenting new circumstances. Grandparents must clearly demonstrate their positive role in the child's life and how continued contact serves the child's welfare. An experienced lawyer is often essential to prepare the necessary documents and provide effective representation in court. There are certain conditions under which grandparents can pursue visitation. These include situations where a parent is incarcerated, has been declared legally incompetent, has passed away, or lacks court-ordered access to the child. If both parents are deceased, have relinquished parental rights, or the child is adopted by someone other than a step-parent, grandparents generally cannot file for visitation. When seeking custody, also known as conservatorship, grandparents must show they've cared for the child for at least 6 months or that staying with the parents would cause significant harm to the child's health or development. The law firm can assist in evaluating whether these criteria are met and how best to present them in court. To file for grandparents' rights in Texas, the appropriate court is typically the one handling the parent's divorce or custody matters. The judge will evaluate various factors, including the emotional bond, proximity of homes, and whether the child expresses a preference to see the grandparent. Crucially, the grandparent must provide strong evidence that being denied access will harm the child's physical or emotional health. Without this, the court will dismiss the petition. It's important to work with an attorney to build a compelling case and avoid the strain of unnecessary litigation. Family Matters law firm PLLC in San Antonio can guide grandparents through every legal step to protect and preserve their bond with their grandchildren. For trusted support and representation, contact Family Matters law firm PLLC at 210-997-2914 or visit us at 926 Chulie Drive, San Antonio, Texas, 78216, United States.